Looks like the parties are ready. And it's my understanding Mr. Pitman will be arguing for the estate. Is that correct? Go ahead.
May it please the court, counsel. I'm appearing here today with my co-counsel, John Heminger, and also my associate attorney, Kristen O'Deek, who helped write a lot of the brief, so I want to give her a little credit. So it's a real honor to be here before the Iowa Supreme Court. So I think right away, 147-140, when you look at the plain language of that statute, it has no causation requirement in there. The certificate of merit affidavit says that you have to have regarding the standard of care and regarding an alleged breach of the standard of care.
Would you agree with me that prima facie language in there causes some eyebrow raising?
It certainly has, and I think that's why we're here. That language itself, I think what it only means is that if you have a case that you are going to have an expert who has to testify regarding what I'll call professional negligence, regarding the healthcare provider, whether that healthcare provider met the standard of care and whether there was a breach of the standard of care and whether it caused harm, so the 4 elements of negligence, then you have to have a certificate of merit affidavit that says, you know, it identifies the alleged or the standard of care and then the alleged breach of the standard of care. It just merely...
You talked about, you always wanted to mention first the two elements that are required in the certificate of merit, and then you talk about prima facie. But the statute's actually written the opposite, isn't it? That it says in a case like this, you have with prima facie, and then it goes and talks about it. Does that matter at all?
That's what I'm talking about. It identifies the type of case in which you have to have a certificate of merit affidavit that says that this was the standard of care and that there was a breach of the standard of care. It just identifies the type of case in which you have to have the certificate of merit for standard of care and breach of standard of care. So, you know, we've had the 3 Court of Appeals decisions that read into this. They read causation into the prima facie language, right? So that, to me, seems to create an ambiguity, right? So now we have to go look at the legislative intent under statutory construction to determine, did this statute 147-140 mean to require that you had to have a certificate of merit affidavit on causation? So when we...
Counsel, isn't our case law pretty clear that when we interpret statutes, if a phrase has an established meaning in the law, then we can apply that meaning?
Broad question, but generally speaking, right? So, but if you're referring to, are you referring to prima facie, that phrase?
Case, doesn't that have an established meaning in our law?
Established meaning, and that's where I'm talking about. It identifies in the type of case in which you have to have a certificate of merit that says standard of care and alleged breach of the standard of care. But they're being read into this that there is now that there is this additional burden of having a certificate of merit on causation. When causation is nowhere to be found in the statute, they explicitly leave that out.
We have sort of a rule that if you have 2 statutes, one's specific and one's general, in a conflict, you apply the specific. Here we're within a statute. Can we follow the approach that says the end of the provision, the one that says issue of standard of care and alleged breach of the standard of care, is the more specific provision than prima facie case, and therefore that controls? Can we follow that approach? The specific controls the general.
Would agree with that, and I think that if there's any ambiguity, which there appears to be, facially when you look at this, then you go to the legislative history. And we know the House bill and the Senate bill both had the requirement of causation in an affidavit requirement. Then when it got to the Senate file, which became the law, they had eliminated that. They indisputably and explicitly removed the requirement of filing a certificate of merit affidavit on causation. So I think...
Prima facie.
No, because I think, again, it identifies the type of case in which you have to file their certificate of merit affidavit. It just identifies that type of case, Your Honor. Yes, Your Honor.
To say that if you don't rotate a patient enough, they're going to get bed sores, and those will lead to problems?
I don't think so. I think that is definitely within the common sense and common understanding of a layperson, right? They call it bed sores for a reason. Now they call them pressure injuries, but they're called bed sores. Because I think most people know that if you lay in bed for one position for too long, you are now at risk for skin failure. And it's clear, just to can demonstrate, if you take your finger and you press it onto your hand, okay, and you look at your hand, your skin blanched. And why did it blanch? Because it wasn't getting blood. It wasn't getting circulation. If it's not getting blood, it's then not going to get oxygen, and then you can have skin breakdown. It's like any other organ in your body. If you're not getting oxygen through the bloodstream, you're going to have failure. Skin, yes, Your Honor.
It did designate experts specifically on standard of care and breach. And when you read their reports, they're pretty detailed and a little bit complicated.
And it was beyond just the manner of transfer, or the way that she was injured on the date of injury. We also were
Care expert reports, right?
care expert reports. Yes, Your Honor. And we did that to be able to cover our bases, to, you know, whether or not there's going to be a ruling, if there's going to be a motion for summary judgment at some time, as far as whether this was ordinary negligence or whether, again, whether it was professional negligence, and, you know, how we would be able to survive that and what is going to be able to go to a jury on that. So,
Bring your basis to do the certificate of merit on those very same issues?
would have, but I thought we had an agreement with Attorney Thornton based upon my prior dealings with him, and also at the beginning of this case. So we prepared.
Say, I can't find anywhere in the certificate of merit language, unless otherwise agreed upon by the parties, blah, blah, blah. I don't see that.
Agree with you on that, but then that gets into the situation of where we talk about whether there was an applied agreement, whether there's an applied contract, in order to be able to contract out of the certificate of merit requirement. And I think a bigger issue is waiver.
Agreements that you're alleging never say in lieu of certificate of merit. I mean, you never use those buzzwords.
Use those buzzwords. You're absolutely correct.
Say?
Absolutely agree with that, Your Honor. I would agree with that.
The waiver issue then? What's your best case for waiver?
Case for waiver is actually based upon what they put in their resistance brief. So prior to their resistance brief, they had not acknowledged that they intentionally invoked the judicial process. So they know they had a motion to dismiss, which we know one of the legislative intention would be to dismiss something early on if it is baseless, and be able to avoid the costs and the time and the effort of involving in the litigation. But they chose to be able to go into the litigation. So on page 26 and 27 of their brief, they actually say that they attempted to learn more about the case in which they were a party, and that they made a decision to wait for expert opinions, and whether it was a good, and which they say was a good one because such testimony was necessary. So they have admitted now in their resistance that they expressly waived the opportunity to file the motion to dismiss that they could have done early on.
A litigation conduct argument, kind of like motions to compel arbitration or challenges to personal jurisdiction, whatever. Okay.
Inconsistent with the right that they had under the statute. They consciously chose to litigate the case and go through the judicial process, incur the expense, incur the time, hire experts, which...
Zealous representation and laying in wait, waiting for time to pass, and make it abundantly clear that you weren't going to file this or anything close to the certificate of merit?
And they put it in their brief on this too. The whole purpose of this was to relieve the defendants of the burden to ferret out the details of a plaintiff's malpractice claim. And so right now with this statute is they can file a motion to dismiss in perpetuity. So they could choose to litigate the case, they could choose to try the case, we could get a judgment, and then they could decide we want to file a motion to dismiss. That doesn't seem fair. That doesn't seem just that you can hang on to that. Yes, Your Honor.
After answer, you have the 668-11 deadline for disclosing experts. I'm reluctant to hold that by doing any discovery, you waive your right to obtain a certificate of merit or to insist on one, because in some cases, maybe like this one or in instruct the issue. The parties disagreed whether an expert was required. So wouldn't a good defense lawyer say, I don't know how the court's ultimately going to rule on, do you need an expert under these facts for the bedsore issue? Maybe you do, maybe you don't, but meanwhile, I'm going to initiate my written discovery. I don't see that as waiving the certificate of merit defense.
It defeats the purpose of 147.140. The intention was for a medical malpractice defendant, for a healthcare provider to be able to dismiss a case early on without having to incur the expense and the time involved in litigating.
Do you then require defense counsel to sit and do nothing until that deadline passes, at risk of, if they do anything, they've blown the certificate of merit defense?
On a case-by-case basis, because in this case, we know that they consciously chose to litigate the case. They chose to be able, they wanted to hear the facts, they wanted to hire experts. So they got involved in this, and they could have dismissed it, a year earlier. So they litigated this case for 361 days before they decided that they were going to file this motion to dismiss, which was a very short time before the trial. Yes, Your Honor.
I understand your arguments about concepts of fairness, but couldn't the legislature have taken care of that? I mean, couldn't they have put a timeline, a deadline for defense to file their motion, an end date, as part of the statute, if they wanted to say that the defendant had to act immediately at the beginning of the case or not at all?
They could have, and they chose not to, but I think that's why we have this court, to be able to determine what's fair and whether that they waived the right that they have pursuant to this statute. So
Or had wanted to authorize us to look for waivers, couldn't they have also included that in the statute?
they chose not to. A waiver is much more of a legal argument. It's much more of whether they do something that's, especially in this situation, whether it's inconsistent with their right, so whether it's arbitration or a motion to dismiss. If you choose to invoke the judicial process, you know, you can waive that. So, I mean, not every, you know, the legislature isn't going to, I think, going to be able to, you know, determine every possible outcome or is situation.
Actions as waiver. Okay, so you named experts. Shall we look at that as a waiver of that you do need an expert for standard of care, for example? I mean, how come it's only a one-way street on waiver here?
Well, because it's their right. Because this is the defendant's right to move to dismiss, right? So that's whose rights you're looking at, whether they waive that. So that's why we're looking at their conduct. It was their right. I don't have the right.
Looking at from the same lens. You want us to look at some of their actions as waiver, and I'm just saying I don't see it. I don't see it in writing. I don't see where the statute allows it. I'm having a hard time seeing that there is actual waiver of that. But if we're going to be looking at waivers, there seems to be some actions on your behalf as well that could be interpreted as waivers.
Our filing of the expert reports encompassed a lot more than what happened in other than just the injuries. I talked about staffing and things like that, which, you know, we pled all of these things. And again, this is just getting into a motion to dismiss. And I think we're getting into a lot more things that might be in a motion for summary judgment. So, but there's no doubt that we did not file the certificate of merit, and that was based upon what we saw was an offer to litigate this case and invoke the judicial process, which they did. The initial disclosures. There was interrogatory. Yes, Your Honor.
More question for you. You talked earlier about that there's no need for an expert, and there's no need for an expert on causation. Is that your position?
That we do have experts on causation, but I think that, for example, if somebody's dropped and they suffer a broken leg, I think it's within the common understanding of a juror to determine that was probably caused by the drop.
Your case goes on to allege wrongful death and things that would not necessarily be within the ordinary understanding of somebody as to exactly why your client ends up dying, those sorts of things.
Could, and that's what we get to a motion for summary judgment on that. I think that if somebody, comes in there, they're risk for pressure injuries, they're not turned and repositioned as they're instructed to do, and they develop a bed sore or a pressure injury, I think a jury, in their common understanding and good sense, would figure out if they're not turned and repositioned and they developed a pressure injury, that was caused by that. Or if the pressure injury becomes an open wound down to the bone, right, and it's necrotic, has foul odor, that means it's infected, and then within a few weeks later than that, there's death from that. I don't think it takes a rocket scientist or a medical doctor necessarily to be able to show that that open wound that they had was a cause of their death. So I do think, but that's something that we should be able to develop, and that would be proper for a motion for summary judgment, Your Honor.
We'll come back to you in a little bit.
May it please the court, counsel. Good morning. I'm here on behalf of Chautauqua Guest House. I think it's important to back up for a second and realize the history of this case from the standpoint of Mrs. Butterfield was admitted to the facility. Yep.
I'd like to turn to 147.140. As I read that statute and the language about the prima facie case, that's a sort of subclause of that paragraph that, as I read it, refers to the type of cause of action. So the type of cause of action is one in which expert testimony is necessary to establish a prima facie case. Then later it talks about what would be necessary in the affidavit, and at that point it says an affidavit with respect to the issue of standard of care and an alleged breach of the standard of care. And so I just, as I read that paragraph, I'm left with this thought that as to the affidavit, it only requires those two things. Why am I wrong about that?
I think you're wrong about that, Your Honor, from the standpoint of what the affidavit requires. I think what this statute does in the prima facie language is what triggers the need to do that. So you have to look at the issue of, does this case require causation to be considered? And if it is that type of case, and it's against healthcare professionals, which the facility is, the CNAs, all those people involved in this were, then, and causation has to be part of that, then it triggers the need to file the certificate of merit. The certificate of merit itself doesn't necessarily have to address the causation issue. And if you don't file that certificate of merit in those types of cases, that's when the case shall be dismissed.
Is that if causation is the only thing that needs an expert, the certificate of merit requirement is triggered. The plaintiff has to file a certificate of merit addressing standard of care and breach and identify an expert that they wouldn't otherwise need to move forward in the case, even though, but not even address causation in the.
That's not my position. My position is all those are needed. Those are all part of the triggering event. Do you have a need for someone to address the standard of care? And was there a breach of that standard of care and the causation? All of those elements go into the triggering of the statute.
Justice Oxley raises the core paradox. I mean, if expert testimony is only needed on causation, and the statute says implicitly you don't need a certificate of merit on causation, what's the point of the certificate of merit?
That's a question for the legislature, but the issue, I'm not conceding that this case isn't one that needs experts for the standard of care. That's why it's important to back up and understand. This lady was at our facility starting in 2017. She was there, and then this incident that occurred, and I want to correct what counsel has said, there was not a drop. There was not a fall. There's a whole fact question of what happened, when did it happen. You can transfer somebody and a break occur, and it's spontaneous. Those aren't common knowledge type things.
District Court here kind of put all that aside and assumed that standard of care and breach did not need an expert, but because causation did, then the certificate of merit was required. Is it?
District court did. The district court didn't say, oh, by the way, it's not needed. Let's,
All right, the Court of Appeals said this doesn't look like a case where you need an expert on.
on page 5 explicitly went through all of her conditions and said, this isn't a case for the common knowledge of people. That's what the Court of Appeals said in this case. And that's why it's important. If you look at plaintiff's petition, as Justice Waterman mentioned in the Struck case, if you look at plaintiff's petition, it's got 69 paragraphs in it. Whoops, sorry. 69 paragraphs in it. Not once do they say this was a routine incident, it was ordinary or anything.
Precedent supports the estate's contention that the care at issue was likely ministerial or routine in nature.
That's mentioned in there because that's one of the potential arguments of why you wouldn't need an expert on standard of care.
But we agree, you know, you needed an expert on causation, right?
Well, I'm not conceding that standard of care isn't needed in this case by an expert. Again, you look at their petition in 69 paragraphs, there's no mention of this being some ordinary thing. As mentioned earlier, they have expert reports that have 70 pages. None of those experts said, well, this is just an ordinary thing that happened. This incident, whatever happened when this fracture occurred, was in May of 2018. No skin issue.
What survives? Let's pretend like you have to assume no experts needed for those two prongs for the standard of care and breach. Let's just, for the sake of argument, a hypothetical expert wasn't needed in this case. We still have the causation prong, and we all know that a certificate of merit was not filed. And so what are we left with? I'm looking at subsection 6 of the statute at issue 147.140. Failure to substantially comply with subsection 1, the certificate of merit, shall result in dismissal with prejudice of each cause of action as to which expert witness testimony is necessary to establish a prima facie case. So what would you have left?
That's the way the court would rule. Then if it went back to district court, all that would be left would be plaintiff to be able to submit a theory that it is just ordinary negligence. They wouldn't be able to bring in expert witnesses saying that there's violation of standard of cares for lack of interventions, lack of assessments, those types of things. Those shouldn't be allowed if that's what the court would be able to rule, because then it would just defeat what was obviously what was required by the statute. And just to finish my point, no skin issues started occurring until January of 2019. And there's all kinds of things that the facility did to try to address that. To say in the brief is just simply wrong. I'm sorry?
Waiver argument, please.
Certainly. There was no waiver. There was never any discussion about the certificate of merit in any shape, form, or fashion.
Argument about waiver by litigation conduct.
The Court of Appeals cases address that also. Participating in doing the initial disclosures, doing initial discovery, those types of things are part of the defending of a case. That doesn't mean that you waived the case. The statute, as was pointed out earlier, makes no provision for waiver. And so in this case, there's no waiver if there's not some conscious agreement that you're doing this. There was never a discussion about, well, geez, you don't really.
Of the statutory right, even by, not explicit, but even by litigation conduct.
So there's no deadline or timeline in which if you don't file your motion to dismiss, you're not able to do it.
Verdict. If a party litigates a case through post-verdict.
And I think by then, these things become moot, if nothing else. I'm not going to sit here and argue to the court.
Trial.
It may sound strange, it may be a flaw in the statute, but there's nothing that would say that that couldn't occur at that time.
At least that I looked at, that has a certificate of merit statute. The states also have a doctrine of waiver by litigation conduct, which is fairly common in a variety of contexts, whether it's arbitration, personal jurisdiction, whatever. Why wouldn't we apply that here just as a general doctrine that courts apply in all circumstances?
We'd already talked about we're still at least 3 months away from trial. There still was a lot left to do. There were more depositions to do, other things to do. So there was still plenty of litigation left to do in this case. It's not like it was on the day before trial that the issue was raised.
History. There are some people that aren't too terribly interested or persuaded by legislative history, but this one seems like one law school should talk about. I mean, the word is there, it's there as far as causation, and then they remove it right before it becomes law. What are we to make of that?
What I would make of that is, one, still the prima facie language is still there, but two, I would also point to footnote number 6 in the Butler case. And in that footnote, the court noted, one, an article by Justice Scalia that talks about relying upon the legislative history as potentially, for statutory construction, is potentially a falsity. And then also in the
No, doesn't this seem like the kind of case that just comes crashing through the window on legislative history? The one word that's at issue? Potential. That doesn't mean sure thing.
if you want to take it in its broadest sense, but then again, you've got to read the statute as a whole. And reading the statute as a whole still leaves the prima facie language in there.
Mansfield was asking earlier about specific and general. Don't we start off with the more general language with prima facie and then it narrows it down as far as what the certificate needs to mention? But
Certificate itself needs to mention is about the standard of care. I'm not arguing and have not taken the position that the affidavit itself has to address causation. Again, the mechanism that the statute set up and the legislative set up was what triggers it? When do you have to do it? And that's where the prima facie language comes in.
Damages part of your prima facie case? Are damages part of a prima facie case?
Well, there has to be an injury, and then what caused that injury? The damage is, it's,
Part of, when we're reading prima facie case in the statute, are damages part of a prima facie med-mal case?
of an injury, yes, as far as dollar amounts.
There was no expert needed for standard of care, breach, or causation, but damages was a little bit wonky, so you did need an expert. Then do you need a certificate of merit?
I think the short answer to that is yes, because of the triggering of the event of the statute. That's what triggers the need to do the certificate of merit. And I think part of the argument maybe why the legislature did that and took it out was the case has to continue to be developed, and you may not know the full extent of damages that may occur throughout the course of the litigation.
When they took what out? When the legislature took?
Sorry?
Legislature took it out. Would it?
That language out in the legislative history that you referred to.
Applies to damages. Why doesn't it also apply to causation?
And that's where the fact that they only required the merit certificate of merit to address the standard of care is not inconsistent with the triggering event of the need to do it.
Counsel, if that argument is right, then how does that last sentence make sense, right? If prima facie case is standard, breach, causation, damages, but the last sentence says the affidavit only has to do with standard and breach, what are we supposed to make of that?
I think that it's simply a two-step process. What triggers a need to do it? Because ultimately, what the legislature is saying in this is, if there's an expert that's going to be needed to address it, do the preliminary step of establishing whether or not there was a breach of standard of care. Was there standard of care and was there a breach? It's just an initial step in the process that was preliminary.
It's only causation that we're worried about, and that's not one of the items that the affidavit has to include.
True with the argument that we're talking about now, but this case also is one, the step is this just one of ordinary negligence like the plaintiff is arguing in the alternative after the fact? That's not in their pleadings. It didn't get presented that way until the motion was filed. And this case is not one, it's more like the Thompson Embassy case that requires and needs an expert for standard of care and the actions that were occurring.
and have you educate me on the record a little bit. This discussion has left me somewhat confused. There's been a disclosure of expert witnesses by the plaintiff with reports, correct? But there was no certificate of merit filed. So the issue isn't whether or not the certificate of merit in this case complied with the statute. It was the failure to file one and the timing. And from what I've listened to you and opposing counsel, it sounds like you agree about the statute, that the statute has a trigger for a prima facie case, and that the content of the certificate of merit need only address standard of care and breach, not causation, not damages, even though those are a part of the prima facie case.
That's what my position is, and I think that's what the statute says.
As well, you guys agree on that part of it, as at least as he just explained it 15 minutes ago.
Confused about his argument just from the standpoint of, really what he's saying is, I don't need to have an expert. And set aside certificate of merit, I just don't need to have an expert. So the discussion about
Issue, all of this is kind of a red herring. There was no certificate of merit filed here, period. So the content and the requirements is not at issue. The issue is whether or not the plaintiff was required to file it at all. And I think he concedes, and maybe he can correct me, that the trigger was met in this case, and if an expert was required on breach and standard of care, he needed to file it. Okay.
Thank you for your time.
You misstate everything that you had said, or is my understanding right?
We agree that there was no requirement as far as causation, right? The question is, do we, in the well-pled allegations of the complaint, whether or not there's also enough in there regarding ordinary negligence, not just what we would call professional negligence, right? And so,
To the claims that do need expert testimony, you would agree that the statute was triggered, it requires a certificate of merit that goes to standard of care and breach, you didn't file it. With respect to those claims, your argument is waiver, contract, et cetera. Okay.
100% tracking. Yep, absolutely. So I don't think there's any dispute that we did not have to, file an affidavit regarding causation, even though that's what the district court judge said, and that the Court of Appeals, in 3 other cases, and including this case, said that you need to have a certificate of merit to address causation. So,
Further, let's assume for the sake of argument, the same thing I went through with Mr. Thornton, that you didn't need to file the certificate of merit for causation. You needed to file it for the first 2, but you're saying, and suppose the court does not buy the arguments of waiver, estoppel, and all the others. You didn't file for certificate of merit, which means no experts. What are we left with? What would your case look like now?
I just want to be clear regarding no experts regarding standard of care and breach of the standard of care. Right.
For that, for an expert, and you didn't, what are we left with?
Left with is that we've got a woman who is left-sided hemiplegic, so she's weak. She is.
What are we left with? What's left of your case?
It's the ordinary negligence. It's the routine ministerial, administrative, non-medical claims that we have.
Being called for those, the standard of care and breach?
Those issues, right? No, so yes,
That you would be able to call had to do with causation?
yes, yep. Yes, Your Honor.
I noticed that in the statute, the legislature specifically created a mechanism for the extension of the time limit to file. And I wonder if that weighs against the idea that there would be other ways to extend your time, such as waiver or estoppel. What's your response to that?
That's just not mutually exclusive. So the statute did not identify all of the ways in which that this could be waived or that you could have an agreement that you did not have to file a certificate of merit. So I think that's when we get back to what does the law say about in a situation like this when you have, you know, waiver by litigation contact or you have an agreement that is shown. I mean, we know from everything that they've done, I mean, they did not have to, according to this 147, 141, that they did not have to spend a nickel on this, you know, before filing the motion to dismiss. And they chose not to do that. And so really that's not, you know, and my other argument is that, you know, this statute is also not intended to dispose of meritorious claims, right? And that's kind of where we're at with this. And so I think the idea is that we would look at, you know, whether the statute, whether they have the right, did they actually exercise the right? And I don't think that the legislature can include every way in which somebody can agree not to enforce it or waive themselves out of it, Your Honor. Yes.
Claim that in response to the chief's question, you said would survive here. If I'm reading the statute and sort of what it triggers, if the cause of action is the type that would require an expert, then you need to provide the affidavit. And as I'm understanding your ordinary negligence claim, you're saying that you would still need an expert on causation. Is that correct?
That, you know, as far as we talked about, if you're transferring somebody, you drop them, and then they have a broken leg, I think it was in the common understanding and sense of a jury that drop caused a broken leg. I don't think you need an expert on that.
Let me try and what if we go in this direction? I'm just saying hypothetically. If we agree with you that the statute doesn't require a certificate of need on causation, instead of us trying to figure out whether your causes of action are and are not require, do and do not require expert testimony or not, since it is only a motion to dismiss, what if we say, if we determine that your waiver argument is not valid, if we reject that argument, what if we just say we will remand the case and the case should go forward, and then at trial and in response to summary judgment, you're not allowed to put forward expert testimony on standard of care and breach of the standard of care?
That is one of the options that you have, and that's one of the alternate rulings that we're asking for you, is give us the opportunity to remand it, build up the facts of the case, and then they will have motions for summary judgment, and then we can determine whether or not we survive past that. But I could understand if the court would say, you know, look, you didn't file the certificate of merit, you cannot have an expert on professional negligence. I told that. We want to just have one of the things is the opportunity to be able to develop the case, and then we can deal with these issues on what happened, how it happened, and whether it's within the common understanding and common sense of a juror to be able to say that it's ordinary negligence, Your Honor. Thank you very much. Any other questions?
Yeah, all right.
Thank you very much.
Of Estate of Butterfield versus Chautauqua Guest Home is hereby submitted. The court is going to take a 5-minute recess before our next case, which is Hauser versus Iowa District Court for Polk County.